Greetings. Welcome back. Today we're going to be discussing Chapter 1. Now this is going to be a short lecture, 15 minutes, which means that I only have enough time to hit some very important topics, discuss them in a little bit of detail, and then move on to the next topic. What that really means is that I'm not covering everything in this chapter, but you're still going to be responsible for knowing what's in this chapter. Why are you responsible? Because I will be testing on what's in this chapter, even if I don't discuss it in this lecture here today. But I want you to know this is an introduction chapter, so that means that at least for this chapter alone, it's an introduction. A lot of things that you've already heard before in your academic career. So I'm not really expecting to test you. I'm not really going to be testing so much on this chapter because you already know this. You've been tested on this stuff before. This is the foundation of where we're going to be going. But there will be questions that come out of here. You're still responsible for doing the review questions here. With that being said, let's go forward with the materials. And I'm just going to go straight through the book and help you understand a lot of the things that are going on here. So the first thing is that your book starts off with discussing evidence altogether and asking the question, posing the question of what is evidence? And in reality, your book takes the correct approach in saying that, well, everything is evidence. And that's true. And that's also the problem. Everything is evidence. And what we're going to see throughout this entire book, and as you listen to these lectures and as you perform any assignment, you're going to begin to realize that, because everything is evidence, we need to establish some structure to the way we introduce evidence in trials and pretrial hearings and post-conviction hearings, on appellate review. All these things are very, very important. These are what create the rules because everything is evidence. Now, let's go through and talk about some basic concepts you've already heard before in the past. Even if you didn't hear in your criminal justice program and any of your other classes, you certainly heard them on TV before. Starting off, what? The burden of proof. What is the burden of proof? What does that mean? Well, it is what it sounds like. Burden of proof. What is your responsibility? That's kind of what it's saying. And the most important burden of proof that you need to know in criminal evidence and in the criminal justice system as a whole is beyond a reasonable doubt. That is the one that everybody's heard of. And that's because it's kind of an iconic thing to say. It's beyond a reasonable doubt. If you can say something is beyond a reasonable doubt, something exists beyond a reasonable doubt, well, you're kind of saying that whatever is the opposite of that conclusion is not really believable. And it's sort of a measuring stick. And if you can say beyond a reasonable doubt, this conclusion, well, at that point, it's kind of like, what else do I have to prove? Now, where is the burden of the beyond reasonable doubt standard apply to? Well, it's not applied in civil cases. In fact, it's never applied in civil cases. It's only applied in criminal cases. And in fact, it's only applied in criminal cases, and it's the prosecution's burden. I'm sure many of you already knew that. It is always the prosecution's burden to prove every element of a crime beyond a reasonable doubt. That burden can never be shifted, meaning that if the crime requires the element of intent to be improved, it is the prosecutor's burden to show that the defendant intended beyond a reasonable doubt whatever act occurred. Now, when we talk about burdens and we talk about the prosecution having its burden, that doesn't mean that the defendant doesn't have any burdens. The defendant sometimes can have a burden. When they have a burden, they have a burden of persuasion. Now that means they have to persuade the trier of fact, which can be either the judge or the jury. Usually, it's going to be a jury. And they have to persuade the jury of whatever it is they're presenting. And usually, what does the defense do? They present a defense. So they have the burden of persuading the jury that their defense exists. Now, again, the burden of proof for the prosecutor is beyond a reasonable doubt. The defendant never has to prove anything beyond a reasonable doubt. their burden of persuasion, the highest it can ever go, is clear and convincing evidence. And that usually is reserved for some really, really heavy-handed kind of defenses, some really like out there defenses. And I'm sure I'm already alluding to it and you're picking up on it. Insanity. That's one of those defenses that's kind of like really out there. And it's like, okay, if you really think that exists, then all right, you can present that, but you got to prove the jury, by clear and convincing evidence that you were insane at the time this crime was committed. Now, things like intoxication, they have a lower burden of persuasion. Intoxication usually has a burden of a preponderance of the evidence, and that's more likely than not I was intoxicated. And you might be asking, well, why do we do that? Well, because insanity is really out there, and it's really hard to prove it. It's not hard to prove intoxication. Why? Because your jury members have probably all been intoxicated at some point in time in their life. So it's easier to prove, it's easier to understand, it's not conceptually hard. And the other thing is that sometimes intoxication is not an absolute defense. Insanity can be an absolute defense. So that's why you may see that difference. Now, you've heard 3 burdens of proof. You're probably wondering, you might be wondering, what is the difference between all of them in the sense of, well, how do we define them? There's got to be some sort of yardstick, some way to measure them. And if you look at least at your book, you'll see there's a definition. There were some jury instructions given to you about beyond reasonable doubt, what it means, and how you can understand it. And I can tell you right now, just by looking at it, I've read it myself. I've actually seen these pattern jury instructions. That's what these are right here. They're pattern jury instructions. The judge is pretty much saying, or the person who wrote these, but the judge would eventually give these, is that you know it when you see it. It doesn't have to be beyond all doubt, just reasonable doubt. And reasonable, that's more of a gut instinct sometimes. So understand that at the end of the day, no one really knows what some of these mean, and you really are in a position where you have to be sitting there, you have to be hearing the evidence, you have to be hearing the arguments, and you have to kind of weigh them and discuss them with your fellow jury members, jury deliberations, to really kind of figure out, was he intoxicated, was he insane, is there any evidence that creates a reasonable doubt. That's how this all works. So just understand that, and you'll be just fine. Now, we got some players. We got some players in the game. If we're in a criminal trial, here are the players. We have a jury, we have a judge, we have a prosecutor, we have a defense attorney, we have the defendant, we have witnesses, we have victims. That's usually what we have. Now, let's talk about the jury a little bit. Jury, their job is to only weigh evidence, and they will determine a conclusion. Sometimes they don't determine death. If it's a death penalty case, they usually won't determine that. They'll determine guilt or innocence. But when it comes to actual sentencing, usually that's reserved for a judge. But they only weigh evidence. That's their main job, is to weigh the evidence and make that guilt or innocent determination. Now, who's the person who determines what evidence to get to weigh? That's the judge. The judge is the administrator of the court. They're the ones who decide questions of law and issues of fact. Issues of fact being like whether or not it's admissible. And you're going to hear that a lot, admissible versus inadmissible. If it's inadmissible, it can't come in. If it's admissible, it comes in and the jury gets to consider it and they get to weigh how much credibility it gets. But issues of fact, whether or not it comes in, that's reserved for the judge because the administrator. Imagine the courtroom is just a giant office. That's all it is. A lot of things going on, and it's the judge's job to make sure that everybody's playing their part correctly. It's the judge's job to know all the rules of evidence, rules of pretrial procedure, post-trial procedure, all these things, motion practice, what the substantive law of the case is. It's their job to administer all this. Sometimes the judge has the role of determining guilt or innocence. It's all facts and circumstances. So, whether or not the defendant wants a jury trial, usually it's up to him to decide that. If he doesn't, then the judge will take it. Then there's the prosecutor. The prosecutor, obviously, as you know, is the one who decides whether or not to go forward with criminal charges once the defendant has been charged. Once the defendant has been charged, usually by a police officer, and they've been booked into jail, the prosecutor will look at the charges and they'll determine whether or not they want to go forward with them. A lot of states differ on how they kind of do that part of the process. Some say, you know what, we're going to let it go straight to a grand jury. Some say that the prosecutor has to present the defendant to a magistrate, determine whether or not probable cause exists to keep the defendant detained. At the end of the day, the prosecutor has a lot of discretion in determining whether or not they want to just say, hey, you know what, dismiss the case. They really have it. Now they have a boss, they have a boss above them, and that will determine whether or not they dismiss the case too sometimes. But they really are the ones that decide, are we going to go any further with this case? I want to spend a little more time on the prosecutor because I want you to understand the type of prosecutors you may encounter, especially for those of you who are going to become police officers. A lot of different prosecutors you could potentially encounter in your career. There are your state prosecutors, and then there are your federal prosecutors, U.S. attorneys. They're really no different. They all went to law school. They all have the same law license. Usually, a U.S. attorney has been a state prosecutor, has been a county prosecutor, and has laterally moved over into the federal system because, federal jobs, everybody likes that. They like paid holidays, the vacation, all that other stuff. And there seems to be some legitimacy behind being a federal prosecutor. It looks good on a resume. Nonetheless, they're the same people, deal with different crimes. If you're working with a state prosecutor, when I mean state, I mean state employee, there's the county level. Everything is divided into counties. Each county has an elected district attorney. That person is, a political official. They're elected. They're elected by the people in the county. The district attorney then will hire a staff of attorneys. Each one of these staff attorneys are what's called an assistant district attorney. The county attorney, the county district attorney, will then also appoint one of those assistant district attorneys to be their chief ADA, their chief assistant district attorney, the right-hand man. And usually those two will handle all the cool cases that you see on Law and Order kind of things. They're the ones handling the first-degree murders and the violent crimes, and they're the ones putting their face out there because they want to show that they're tough on crime because they gotta please those electors. The assistant district attorneys, they're going to handle everything else. That's your job. Whatever it is, they're going to handle it. And of course, they have their support staff, their administrative staff, clerks and stuff like that. With the U.S. attorneys, it's a very slimmer breakdown. There's a U.S. attorney who's appointed by the president. So that means they're not elected. They're not an elected official, and they can serve in their position for as long as a president wants them to be. Now, it's not like a judge where once the judge is appointed, it doesn't matter who the president is. That judge is going to serve for life until they're either retired or they're impeached. For a U.S. attorney, they serve at the pleasure of the president, meaning when there's a new president, usually that U.S. attorney's out. But sometimes, the U.S. attorney stays. Nonetheless, they're appointed. So they don't have to please the electors, but they're still handling the big important cases. In for U.S. attorneys, it's usually the big federal racketeering charges. Those are really, really big, and those are the ones that we're getting that they're handling. Then they have their assistant U.S. attorneys, and they're handling everything else, much like the assistant district attorneys are. So those are the kind of the players you will find with attorneys, with prosecutors. So to say, I apologize for that. Now, the defense attorney. This is very important to know about the defense attorney. They are an attorney. and the reason why I want to make that just known is that they are no different than a prosecutor. A lot of people tend to think that, defense attorneys, they can be the scum of society. They're the 1% of every attorney who gives lawyers a bad name, when in reality they have an ethical duty. They have an ethical duty to zealously advocate for their client, and they have an ethical duty to present every defense possible. So sometimes, yes, they present a defense that is completely out of this world, but the thing is that they have an ethical duty. It is our ethical duty as an attorney to present that defense, and if we don't, we can get in trouble by our licensing boards. So it's important to understand that fact. But other than that, they're an attorney, just like any other attorney. Now, let's talk a little bit about the sources of law. you have the rules of evidence, you have statutes, and you have the Constitution. And that's how it works for both the federal and the state governments. The federal government, of course, we have the United States Constitution, we have United States statutes, and then we have the federal rules of evidence. For states, we have the state constitutions, we have the state statutes, and we have the state rules of evidence. There are other things in play, but at the end of the day, that's all it's broken down as. It's important to understand that the Constitution reigns supreme. The U.S. Constitution is up top, the Supremacy Clause. It's up top. Then it's federal statutes and the federal rules of evidence. They all apply in federal court. If we're in state court, it's the federal Constitution and federal statutes, if applicable, that apply. But otherwise, the state procedure laws, state rules of evidence are going to apply. So make sure you understand that distinction. But, just a small but, most states have modeled their rules of evidence after the federal rules of evidence. So that means, and this actually includes West Virginia, whose West Virginia rules of evidence look almost identical to the federal rules of evidence. Same goes for the North Carolina rules of evidence. They look identical to the federal rules of evidence. And that's usually because states like to sometimes let the federal government lead the way and let them make all the mistakes and kind of go through all the growing pains. And when they figure it out, then the states will come in and adopt whatever they do. It's usually how it works. Now, I didn't go through everything like I said. There's some things about the United States Supreme Court and case law that I didn't go over. You're going to have to answer questions on that for the review questions. But it's important. We got a basic foundation here with this lecture. Do the review questions. Get ready for lecture 2. Be prepared to understand the things in chapter 2 so that when you watch the chapter 2 lecture that you know what it is I'm talking about. And I'll see you next time.